investment protection in an age of armed conflict, energy security, geopolitical risk, and the future of foreign investment. Now, before we dive into the heart of the matter, I want to extend a massive thank you to our moderator for today, Dr. Omar Bulut. Dr. Umar Bulut actually is the inaugural president of the Turkish chapter of our young OIC arbitration group. Omar, thank you so much for stepping in to moderate this session today. Your
Thank
leadership
you.
with our youth chapter, is stellar, and we are incredibly grateful for your agility and expertise. Now, I also want to thank our phenomenal panelists. You have generously agreed to step up and unpack some of the heaviest, most pressing legal and economic issues of our time. We know what is happening now in Hormuz Strait. It's like almost every day we get something new. Now, Dr. Bolot will properly introduce each of our speakers. Again, I know he's the best to do that, so I'm not going to do that. He's going to do that in a moment. But to all of our panelists, I want to thank you for being here with us today. Now, during today's webinar, we will explore where investment law intersects with geopolitical risk and energy security. But if there's one core takeaway I want to emphasize today, ladies and gentlemen, it is this. We have to change how we think about conflict or disputes. In international trade and cross-border investment, a traditional dispute, whether it goes to a local court or a full arbitration tribunal, is often a symptom of failure. It costs time, drains capital, and breaks down vital strategic relationships. In an unstable global climate, waiting for a dispute to fully blow up before you take action is a luxury no one can afford. Therefore, by implementing robust dispute prevention and mitigation strategies early on, in both contractual setups and state-investor relationships, we can spot the risks before they erupt. Therefore, dispute prevention and mitigation is how we protect supply chains, secure energy corridors, and keep vital partnerships alive despite geopolitical headwinds. Therefore, proactive mitigation is what will separate the resilient investments from the vulnerable ones in the coming years. Ladies and gentlemen, as an institution, the OIC Arbitration Center, we aren't just talking about modernizing, we are actively building the infrastructure to support you. To that end, I'm incredibly proud to announce that we have officially launched our new digital case management platform. Right now, my team is dropping the link. They're going to do that shortly to the platform directly there, into the Zoom chat. I highly encourage everyone on this call to click that link, bookmark it, and explore it. We built this platform to make your life easier. You can now file cases completely online, whether it's a mediation or an arbitration case. If you have clients facing active disputes, they can use this portal to initiate proceedings instantly, nominate you even directly as a sole arbitrator. Yes, you can be nominated, or they can decide to choose from our distinguished international panel of neutrals via a simple drop-down menu you'll have on the platform when you log in. We know that transitioning to digital platforms comes with questions, so we will be hosting a dedicated webinar on digital case management in international arbitration in the coming months to give you a full step-by-step walkthrough. Now, to close, I want to thank every single one of you for taking the time out of your busy schedules to join us today. Your ideas, your practice, and your engagements are what drive this monthly series forward. I'm looking forward to a brilliant, dynamic discussion. Dr. Bulut, the floor is yours. Take it from here. Thank you.
Thank you, dear Secretary General. Thank you for your very kind words, and thank you for your continued support for the Young OIC group and for the center as well. We are very grateful for that. So good afternoon, everyone, and good morning or good evening to those who join us from other time zones. It's a great pleasure to welcome you to the OEC Arbitration Center monthly webinar series. My name is Dr. Ömer Erkut Bulut, as Dr. Hosseini introduced me, an assistant professor at Boğaziçi University Faculty of Law and inaugural president of the Young OEC Arbitration Group's Turkey chapter. I'm delighted to moderate today's webinar on investment protection in armed conflict, energy security, geopolitical risk, and the future of foreign investment. This is a particularly timely and important topic. Armed conflicts, geopolitical tensions, energy security concerns, and economic fragmentation are increasingly shaping the global investment landscape. Investors, councils, states, and arbitral tribunals are all facing similar difficult questions. How should investment protection operate in times of conflict and instability? How do geopolitical risks affect investment flows and investor confidence? And how should legal and policy frameworks respond to the growing centrality of energy security? For me, this is also a topic of particular interest. My doctoral research at King's College London focused on investment protection in disputed territories, so naturally a subject which necessarily touches upon armed conflict, prolonged disputes, or the legal consequences of territorial and political instability for foreign investment. So I'm especially pleased to moderate a discussion that brings these themes together in such a timely way. Today, we are very fortunate to have two distinguished speakers on the matter, both of whom combine academic expertise with practical experience in the field. Our first speaker is Professor Dr. Rafael Heffron. He's a professor and dean of the College of Law at Abu Dhabi University. Professor Heffron is widely recognized as a leading authority in energy law, energy justice, and the legal dimensions of energy transition. His work is particularly relevant for today's discussion as questions of energy security, geopolitical risk, and investment protection are now more closely connected than ever. Our second speaker is Dr. Ana Maria Daza Vargas, senior lecturer in international economic law at University of Edinburgh Law School. Dr. Daza Vargas works at the intersection of international economic law, investment law, and dispute resolution. And I believe she has also been involved in investment arbitration cases where questions of investment protection, armed conflict, and political instability are closely intertwined. This makes her perspective especially valuable for today's discussion. And again, I would like to thank the OEC Arbitration Center for hosting this webinar and for its continuing support of the Young OEC Arbitration Group. Please consider to join wherever you are in the world. And particularly our Secretary General, Dr. Omar Husseini. I would also like to thank our speakers for generously joining us today and all participants for being with us. With that, let me warmly welcome Professor Dr. Rafael Heffron and invite him to begin with his remarks.
Thank you.
Professor Heffron, please.
Thank you. Can you hear me okay?
I think we can.
So thank you very much for the introduction. And it's a pleasure to join everyone here today. And I send thanks to the Secretary General as well as to yourself, Dr. Omar, and all your team as well. And let me begin by sharing, I have a brief presentation. So what I want to highlight today in particular are a couple of key issues. And let's say for myself, coming from the energy sector space in particular, I want to really touch on one of the new ways in terms of energy we are thinking of how do we de-risk, let's say, energy contracts or decision-making in energy policy making. How do we try and bring in a more risk management approach to this? And this, for me, is an area that's going to grow and grow, and particularly because it will help in terms of dispute resolution, but also in terms of moving projects, moving company relationships forward at a local, national, and international level. And that's what we want to see. Because remember, for me, when we talk about conflict, and we've been given the title today in terms of thinking about armed conflict, and my view is armed conflict always crosses over into some type of economic conflict. And what we have to think about is shortening the exposure to a conflict scenario. So conflict can happen in many different ways, but how can we reduce the impact? And for me, that's where risk management comes in, but also I will briefly touch on the issue of resilience. So when one is operating through times of conflict, it's going to become, to me, an obligation for companies, governments to show that they tried to have a more resilient strategic or policy perspective and then move forward. So I will begin. I think there's already been an introduction to myself, but I'll just say that, I'm speaking today from Abu Dhabi University, so near, let's say, and, in a country that has experienced some of the recent conflict. But my own experience crosses into different areas in the world, so it's nice to see a global audience today. I've completed work for the African Development Bank, the Asian Development Bank, also different development banks in Latin America, and worked, the majority of my career, let's say, in the EU. And my research to highlight how important energy law scholarship, sustainability scholarship has become is in the top 1% of most cited research. And that reflects, alongside, let's say, scientists, medical scientists, who engineers, legal research is going up in those, let's say, in terms of importance. And I think, areas around dispute resolution are just set to become more and more important, but increasingly we will have to work with other disciplines to really move it forward to an even higher level. I also want to say that, here at my university, we have a Law and Security Futures Research Centre. So when you're thinking about these issues, sometimes things may not happen in the next year or two, but we are doing things for the next 4 or 5 years, or even longer term. Many countries have economic plans until 2050, 2070, and we should bear that in mind when we're thinking about, risk over time and how that is legislated for, how the economy may develop. And just to go back to a final point I made at the start, when we think of resilience, given the different shocks to the economic systems today, we're touching on armed conflict today, but equally, there's probably a few European colleagues and my fellow guest panelist speaker, is speaking, well, I believe from the UK. So, I mean, if you were in the UK, you'd be talking about the shocks due to the weather, the heat wave. So all across the world, we're experiencing these different issues, and how are we going to manage them? And I think what we're seeing today echoes a couple of words that were touched on already, that link with global supply chains. 20 years ago, globalization was one of the most popular themes around, and we're seeing the product of that now interconnected global supply chains. And that's really why when there's a small shock to the system, there's an impact on, let's say, the propensity for foreign investment. And in essence, the risk, the nature of risk for different stakeholders, let's say, in the business world. So for me, I will touch on the issue quickly in terms of energy. We're thinking of international to national to local issues, and we can see this today in terms of the energy crisis globally and how countries are trying to respond, or different regions of the world are trying to maybe in some cases work more collectively together to achieve a response. You could also argue the other way around and say what this current armed conflict crisis has shown, countries are willing nearly to go in a more independent way in some parts of the world. In other parts of the world, there is a more a bigger sense of maybe cooperation. So for me, over the last couple of years, what we see is, academics working a lot on different issues. But when we're thinking of something like conflict, we see increasingly a perspective of working towards a perspective on justice. And for me, this is very important when we consider, how legislation is being drafted currently and into the future. And then we think about trying to get different, procedures internationally related to arbitration or dispute resolution. How will they be drafted in future? And my view is we are going to see a more just perspective. And when I say just, you could take it from a more practical point of view, and I believe that is taking the situation with a more risk management perspective. But what are those principles behind that risk management perspective? They are within justice. And I, highlight this, that this is not just, me saying this. This is just one example of, from my own research, but there are many other legal researchers out there working in this sort of justice area across many different areas of the law. And these ideas are going into policy and legislation. They are being drafted that way. So very soon, I expect to see some of this same terminology begin, to appear in, issues of dispute resolution. And I know that they already are, but I think they will become more dominant in terms of the wording. And the idea here is linking directly with this, the final few words of this line, increasing just outcomes globally. Because when we think about this armed conflict, we do want to see business continue. We do want to see business relationships continue. People want to be in essence, a win-win scenario. So it's not that the investors and investment protection is going to reduce. We are still working to try and have successful business relationships. But here's a slide for me which reflects back on the past, but looks forward to the future. And this, in the context of today, we're talking, one of the words or terms we're talking about is energy security. Energy security, very important globally, but the essence of energy security can be seen in the fact that the European Union is a major region of the world today, but it was created due to the energy security problem. It was formed on two treaties, essentially, to manage energy resources: the European Coal and Steel Community Treaty and the Euratom Treaty for nuclear energy. And what we can see today around the world, you can ask questions, when we see conflict, we can see the importance of the energy sector. the energy sector is the key part of our economy, which defines usually whether we will have a economic growth or, in essence, a stable economy. One of the biggest reasons countries lack economic stability is because they don't have a stable access to energy resources. But if you're looking at the different reasons here, you can see there are many different reasons why we have change when we are thinking of international energy law. And this is why I want to place it in context. You know, energy security and conflict in terms of armed conflict is not in isolation. We've had different experiences before. To give you one example, remember some years ago, I suppose maybe around 15 years ago, close to 15 at this stage, we had the Fukushima disaster in Japan. And what that did was a major safety issue for nuclear energy. And nearly overnight, nearly the majority of nuclear reactors around the world were stopped, and each one had to do an inspection. And this, you know, is a impact of nearly having a global energy system, that we do have the International Atomic Energy Agency. There is that system in place for, you know, governing safety in nuclear energy operations. So there is international law there, you know, and what we need to be thinking about is we do experience these shocks from time to time. So whether it's safety, it can be security like we're experiencing today due to the armed conflict. We've also issues of economics, low cost. You know, we are seeing today the rise of solar energy, in particular because countries are able to reduce the cost of solar energy, let's say within 10 years by up to 80%. So, I mean, this is putting pressure on, you know, investment choices where, you know, there is already disputes in this area where, you know, particularly maybe coal or gas projects have been told they would get permission to go ahead, but along comes another technology choice, which is much cheaper. And, you know, then there is an issue of investment, let's say protection. We also think of the demand for new energy infrastructure around the world. We think of issues of justice in terms of thinking about the impact of climate change, and we can see that across the world. You know, over the last few years, all across the world has experienced key impacts from climate change. We also see technology and ownership becoming more and more important, and I expect in the next few years, we will see technology become even more important as more people can utilize different types of energy technology, particularly, let's say, battery technology, where that will support personal consumption or even consumption, let's say, at 2 or 3 households, and will reduce, you know, that need for maybe central energy supplies or central electricity supplies. So there is big change to come, and particularly when you have technology and economics working together, and the cost reduces even further as it is expected to do. So what do we see? You know, if we're looking at some of these issues, we're seeing, you know, on one hand, we have the conflict. The current conflict today is war. But there could be other conflicts. We already have seen over the last few years climate change issues. And if we're looking at things objectively, perhaps the war did not have maybe as big, it has had an impact, but maybe it hasn't had as big an impact as some would think. And I think that's because the world and different countries were already used to issues around the increasing rise of the impact of climate change, which I'll highlight in a minute. But also, you remember a couple of years ago, we already had the impact of COVID-19, the subsequent economic crisis after COVID-19. You know, that was let's say, a crisis due to a global health crisis. But we've also seen more and more the issues around global supply chains. And this is via the rise in globalization, which occurred, roughly between 1990 and 2010, a major push on globalization. And what we need to think about is there's always some key issues. And when we see these different types of conflict, whatever it is, we always see energy security returning to the fore. It always is a vital issue that needs to get solved first. Then issues around economics and infrastructure. And then finally, that latest issue of ownership and technology. And I think, as I said, that's where all of us will, become even more part of this process. But, when we think of the impact of the war this year, we can also think about other big impacts which are happening at the same time or have been happening for a few years now. But just to point to one of these on climate change, you look at that figure, and Deloitte, one of the top four, let's call it leading consultancy and accountancy firms, they highlight that climate change could cost the world's economy 1.78 trillion by 2070. These are huge sums. So you can imagine the disputes are going to rise and rise as who is held accountable or who is responsible is discussed even more. But there's another one here, the report below, and that highlights the cost of inaction. And actually today, the cost of inaction on climate change issues has been shown to be higher than the cost of a country acting on climate change issues. And to me, this really shows the importance of action both by companies and by governments. And it brings into that question I was talking earlier of that issue of risk management and resilience. So has your company, has your government made that decision to manage things with a strategy that utilizes principles of risk management? Have they planned things to be a more resilient economy or more resilient company? And I think what we can say today is, if you were out to ask me what is one of the big changes after this conflict of war, I mean, we need to see that these different types of conflicts in different ways are happening nearly every 18 months to 2 to 3 years. They are becoming regular occurrences ever since we had the global financial crash in 2007 to 2009. We've had repeated different shocks to the economic system, or you could call it repeated different conflicts. And what I would say is, if your company or your government aren't acting, if they've been inactive on this front, you have to think that they are contributory negligent in some way. They shouldn't be able to pursue potentially a client or a customer they shouldn't be able to pursue them for the full 100% if there's evidence that they did not look to act or be a more resilient enterprise or organization because they were facing these particular issues. So for me, what I would say is, as a reminder, unstable energy supply is the biggest cause of an unstable economy. So we want to remember that principle, that we really need to think about that energy security issue. My view is investment protection is going to reduce. So, as you have this realization of the greater importance of energy, it directly affects supply chains. It links with issues of climate change, which can compound issues at a national level. Energy security becomes more and more important. Countries are less willing to maybe trade on particular issues. But in essence, my view would be investment protection will reduce. There's a sort of fragmentation that is going on, and it will be hard, it'll be harder to have that investment protection because I think countries can feel the sense of international fragmentation. And this is why managing that risk and evolving resilience of your organization, whether it's public or private, become more and more important. Because again, you want to be showing your, for example, your owners, your investors, that you realize some fragmentation is going on. Your investment may not be as protected as it was before. So you need a better risk management strategy. Those decisions need to be, let's say, much more evidence-based, and there also needs to be an underlying resilience built in, that if something goes wrong, you're able to manage that situation faster so that, let's say, maybe accumulated losses don't rise maybe as much as they otherwise could. However, if I'm to look around the world today, I would say there's one region in the world where they still seem a bit oblivious to what is happening, and I just use it as an example, and that is the EU. And for me, the EU still believes that in the world of, that they have great expectations. I think they are largely being left behind in terms of some of these issues. It's unclear what the path forward is in the EU. And why I say that is, you see the demise of economic competition, the realization that competition, is not maybe always the best policy in different sectors of our economy. And again, how we manage this, is competition the best way forward? Well, not really if you want energy security. The majority of countries, in my view, which have good energy security, they didn't really have that much competition in their energy sector. They had some, but maybe to drive technology forward, but not to the same extent as the EU. And also you see a major, if you wanted a case study of the indecision or the, what's happening in the world today, you would look at the EU, because again, you have many countries in the EU, having second thoughts really about investment protection and thinking about it in a different way. So all these show me that even in what was once thought of as a secure economic bloc in terms of the EU, a big group of countries, this group of countries are becoming more fragmented. And for me, it's like a case study into the wider world of, what is going on in this area. So, for me, it overall shows the importance of the role of justice in lowering risk. And to me, this is, the essence. A lot of us are lawyers here today, and for me, it's, it's sort of a good time to say that justice, the heart of a legal system or the heart of law, justice, is actually coming back to the fore. And that if we see justice as about bringing in risk management, it actually presents a very big opportunity, to ensure that we have a better risk management policy. We ensure we have a more resilient economy through having more resilient organizations. And then subsequently, we, can use these principles as a way of, better deciding on the disputes that are going to occur in, let's say, what is, for me, going to be a more fragmented world. So Some of the principles that we can use, and I'll go quickly through this because I can provide this in more detail for anyone who wants to read it research-wise. These 5 principles: distributive around the finance system, procedural around the legal system, restorative, correcting and preventing injustice in the system. Recognition is about who is at the table locally and nationally, and cosmopolitan, about who is involved at decision-making capacity internationally. So we can see these principles being used a lot over the last 10 years, research going up. We can see them being used specifically by different countries, both developed and developing countries, US, Colombia, South Africa. They are used by many more. We can see the principles being used by international organizations, the IAEA, the one responsible for nuclear energy I mentioned before. Also the IMO, particularly for the shipping industry, is utilizing some of these. And again, that directly links with that issue of global supply chains. And we think they are being used by these international organizations. Why are they being used by these countries? They are being used in their long-term energy and climate projections because they're thinking, what is the best way to manage risk over time? And the more you can show you're trying to manage risk, the more you should be able to borrow money at a cheaper rate off financiers, because you can show how you are being proactive to risky situations such as conflict, armed conflict, rather than having this more reactive approach. So we think of issues like the UN SDGs being reformed over the next couple of years. So again, this is again a period of time for me over the next, basically to probably 2031, where we're going to see more and more disputes arising because, you know, everything is becoming a bit more fragmented. It's a difficult time, I think, for the world to be renegotiating the 2030 Sustainable Development Agenda that we need. It's a difficult time to renegotiate the Paris Agreement. Like the last time the Paris Agreement was negotiated, 195 countries signed up in 3.5 years. That increased investment expenditure on climate change, let's call it lowering climate change, lowering carbon emissions in the energy sector, investment increased by something like 400%. Would we see the same today in this fragmented world, you know, with no full agreement in place for what will happen after 2030? I'm not so sure, but if anything, it will lead to more conflict. And, you know, for, scholars in my area, we're thinking more and more you have to use that data. As I said, you're trying to show risk management in detail. You're trying to show how you are trying to be more resilient as an organization. Various data available to you, IPCC reports, more and more insurance data, which is vital for any investment, economic data, socioeconomic data, health data, environmental data. And I've already seen different energy projects not going ahead because in essence they can't get insurance, or because they have had substandard health and environmental data. And I just want to raise another key issue. When we talk about economic data today, there is a difference. There is general economic data, but there is also socio-economic data, and that shows the issues of the rise and, let's say, of inequality into decision making. And again, when we think of, you know, something like armed conflict, it comes with lots of different problems, issues around jobs, issues around migration, issues, you know, all these issues rise and rise. So it's not, you know, conflict isn't just directly in one country, it spreads across regions, and that's what we see today. And here is, you know, some of the issue of justice being incorporated into decision making. And I just want to highlight this has been already used in Australia to promoted at a national level by researchers to incorporate justice into energy decision making. And again, it links different forms of justice to issues around data from science, but also issues around risk insurance are becoming interlinked directly with issues of justice. So when we think about drafting, we think about, solutions or, just tribunals, how they make decisions. It should be incorporating this latest sort of views in that are happening, let's say, in both research and in practice. And I just want to highlight this one that in one of the biggest journals in the world, and it's directly talking about using these justice principles as a risk management tool. And, for these journals to be focusing on topics like this is really important from a scientific perspective. And the idea here is you're looking at how justice, and you're documenting justice in a way where you're saying, look at the different stakeholders, how did their situation improve? And you're looking to say, this was justice in operation, a baseline scenario of what was happening. And you're looking to manage risk, reward, and responsibility between the three stakeholders of governments, private sector companies, and citizens. And you need to show how you tried to manage risk, reward, and responsibility. And that goes.
Professor Heffron, can you please wrap up slowly?
Yeah.
We have like some time constraints. It's a very
Yeah.
rich and amazing topic, but we are sorry that we are constrained by time.
Yeah, no, I can finish directly here that this
No, like just slowly wrapping
Yeah.
up, like not finishing.
Yeah.
Just
no, well, this was the key last slide, that it shows you how far we've come in terms of thinking about justice, and already out there they're saying, you have to be thinking of justice from how justice will manage risk, reward, and responsibility. And we infuse that into our decision making. And in essence, that will avoid one of the biggest cost issues in the energy sector today, are disputes, between the different stakeholders. So if we want to reduce disputes in the energy sector globally, and let's say today it's for armed conflict, tomorrow it could be for some other conflict in a different way, we need to be thinking about that management of risk and building in resilience. So essentially, this sums up my final point, that inaction stops growth and innovation at a national level. We want an institution and principle-based approach, and we need, in terms of disputes, accountability and evidence. And this milestone reporting helps to track data like that and show how it has evolved over time, and can ensure essentially better investment protection if you have these three issues, or if you have these three focuses in an economy. And if they don't happen, I'm afraid, for me, we will see the fragmentation process increase. And I think investment protection will be harder and harder to achieve for certain projects. Thank you.
Thank you very much, Professor Heffron, for your really like multi-layered and rich presentation, which was very educative, informative, and thought-provoking for everyone who are interested in these topics. By the way, you can also type your question for the participants. You can type your questions in the chat, so to our speakers, and our speakers can answer after their presentations. So, having said that, giving that note and reminder, now we turn to Dr. Daza Vargas. Dr. Daza Vargas, please, the floor is yours.
Thank you. Can you hear me?
I can. I think we can, yes.
Yeah, okay, it's fine. I just got a strange message in my screen. Well, thank you very much for the invitation to the Secretary General of OIC and to you, Omer, for this discussion. It's very interesting. I think it's very timely as well. My focus generally is international investment law and arbitration. I have experience of different kinds in the management of natural resources, including water, energy, and all that related to the extraction of and enjoyment of natural resources. So I wanted to start by saying that the issue of armed conflict and security in international investment law, not in international investment law, and the intersection. We had the opportunity to test some many years ago with the initial conflicts around the Arab Spring, for instance. The first questions that we tackled with from an academic and from a practical perspective were like, do the investment treaties still apply in armed conflict? Do we have a situation of exception or not? And we quickly learned that yes, international investment agreements still applied, and protection was still owed to investors, foreign investors in the countries, in the host states where the conflict was happening. So we start there, and then the next question then was, what is an internal armed conflict? What is a war? What is an external armed conflict, etc.? An international armed conflict, more specifically. And we discovered that then the state had different treaties, and among these treaties, the states could either choose the OIC investment agreement or choose their own bilateral investment treaties with investors. And that is a question of, a lot of due diligence for lawyers, for claimants, because they had to decide, well, what is that the OIC can offer to investors in terms of protection, how specific it is, how I will use the word generous in terms of investment protection, in standards of protection such as fair and equitable treatment, full protection and security, protections against expropriation, etc., and especially compensation. So in many cases, we saw at the time, and I'm talking about 2010, 2009, 2011, that many of the countries, in the example, for instance, of the cases that brought against Libya, chose their bilateral investment treaties that at the time, seemed to have a much broader protection. And I would do a parenthesis here, because if that is beneficial for investors, and I pose the question here, it's not an answer of mine, but suggests that perhaps the OIC treaty offers a much balanced approach in terms of the right to regulate for states, right? Article 9, for instance, of the OIC investment agreements really impose an obligation to investors to comply with the national legislation, to the laws of the host state. And interestingly, that article has been interpreted, for instance, in the Al Warraq versus Indonesia case, in which the arbitrators interpreted that Article 9 could give rise to counterclaims. Just the interpretation was given, but it was not tested because the respondent couldn't prove the counterclaims. But it's an interesting starting point in terms of this balancing of rights and obligations. So an interesting treaty. I think there are many, many more cases now than before. I was looking a little bit earlier of how many cases, and I think it's over 20 cases now under the OIC treaty. And it will be interesting to see what kind of decisions are going to come out of this treaty, because it is also an issue of, and I go to the second part of this, of the theme of this discussion, to the region, right? To the geopolitical situation specific to the countries that have joined this treaty. So I'm going to now make or suggest a sort of comparison between energy security in the Middle East, in that part of the world, say to Europe or even to Latin America, that is my neck of the woods. And we have a situation there where we still have different priorities. Europe, perhaps, and other countries are obviously trying to move towards transition economy, a transition from fossil fuels to renewable energy. And there are now questions on that point of new markets. And I think a great example of new economic markets is, for instance, the issue of Spain and the solar energy. When you create a new market, you can provide perhaps and offer many incentives, many subsidies or feed-in tariffs and all this. But because it's quite a new market, you don't know how it is going to react. You can give too many incentives and then expect a good turnout of investors, but also you can receive too many investors and then an overoffer of energy, such as more or less what happened in Spain. So with that, the state needs some sort of adaptability, resilience to try to go back to the economic efficiency that it had originally planned. But obviously, this affects the guarantees that have been given to those investors. So that is one possibility on these energy markets. On the other hand, you have the other region, the region where the OIC countries are. And here you have nowadays a situation of political instability, of war and armed conflict. So how you tackle with this situation is a little bit different, right? It's more a question of due diligence. It's more a question of to what extent these host states are obliged to protect the investors. And I will go back again to the various cases that we brought against Libya, because some of the questions that many investors posed was like, to what extent the state was under the obligation to protect or provide full protection and security to these investors. And the decision of arbitral tribunals were quite different in each case. So it will be it's interesting to go and see what is the approach of every tribunal to the obligation of a state of full protection and security. We all know that this obligation is not an obligation of result, it's rather an obligation of means, of due diligence, and to what extent the state has the possibility to provide this protection. So that is another issue that is also very important, because it looks and allows to the arbitrators to look at the situation of each country in the context in which the armed conflict is happening. So, you will, if we consider different approaches of tribunals, that will have different views as to, for instance, the situation in Ukraine and Russia, to what was the situation in Libya, to what was the situation in Egypt at different points in time, but also in connection to the obligations of states. In terms of arbitration, I think it's a very political issue as well. They put a lot of pressure on arbitrators to have to express opinions, or at least perspectives into how they see the situation of the armed conflict. Now, in terms of risk, yes. In terms of risk, I'm going to move now to the issue of adaptability. I think in both types of investors, investment in energy that continues to be in oil and gas, and new investments in renewable energy, we have the same situation of risks. As I was saying, I think one example is the example of Spain. And the other example is the example of investments in the Middle East. And then you have another example, for instance, of investments in Africa, also related to energy, because renewable energy requires a great deal of mining activities. you know, of lithium, of cobalt, of all kinds of nickel, etc. So this has a different type of risk because it's very much, you know, to what extent this kind of mining is different from the traditional mining. You will still affect natural resources such as water. You will still affect local communities. You know, there is still a big risk against the environment. So where do we find this balance? How do we treat these bigger questions? Technology is one of those, but also the relationship of the investor himself towards risk. There are various examples, for instance, where investors will go into a country, take much more risk that they are actually willing to embed in their tariffs, which means that the price, you know, that is a perverse incentive of investors sometimes to not disclose all the risks that they are dealing with, because they have to show the governments that the tariffs are going to be competitive, they are going to be a competitive market and all this. But then when the conflict comes and when there is an investment dispute, the investor has to show the arbitrators that this project was always able to reach the end, and this is how we move into the calculation of damages and international investment disputes. That is one of the issues that is very much contested at the moment. You probably know that some of the most important discussions currently in the negotiations of UNCITRAL Working Group 3 on the renegotiation of certain issues, of procedural issues of international investment arbitration are discussed. And one is the standard of compensation, right? To what extent investments should be paid for the whole life of the project or only for part of the project? To what extent investors could show that they would have continued with investment and finished the project, even though when there are risks of war or a technological risk or market risks, etc. So I think that from what I just explained, you have a chain of different elements that need to be considered by arbitrators, by the communities, but especially by governments when they prepare the new policies. Adaptability, I completely agree with Professor Heffron. Adaptability and resilience are two elements that are absolutely important for states, but it's an element that needs to be reserved for themselves, you know, reserve this right to regulate, to be very clear with investors that at the moment, the only predictability is instability. The need for adaptability, but there is no other at the moment. We are going through a process of big changes, of big transformations, and that shows us that we are going into a very unknown world, and that is precisely this unknown that we cannot put a pricing, right? We can't embed the cost of the unknown risk into any possible tariffs. And that makes new investments very risky for investors, and will require a lot of adaptability. Working together with governments, I completely agree. I think the Secretary General was speaking before about prevention, mediation, conciliation. I think the OIC is one of the treaties that includes conciliation in the dispute settlement provisions before before arbitration, and that is important because it requires the parties to engage in meaningful negotiations. That is a principle of customary international law, and that is very important. So if you don't manage with the government, if you don't manage with the regulators to reach an agreement, then yes, you probably will have to go to arbitration. But I think there are increasingly more mechanisms to try to bring investors, government, communities together for negotiation before we get into investment disputes. I think that is all I have to say. I would like to hear questions and have an interested discussion, because I think there is a lot of food for thought. Thank you very much for your attention.
Thank you very much, Dr. Daza Vargas, for this again like very enjoyable and informative presentation, which combines both the theory and the practical background, also the applicability of OECD Investment Treaty and other very hot topic in these contemporary challenges. So I see we have a couple of questions. First from Dr. Ömer Faruk Kafalı, who is also our professional development coordinator at Young OIC. So the question is, war clauses and full protection and security standards were designed for a more stable order. Are they fit for an environment of sanctions regimes, asset seizures, and weaponized energy supply? Or has conflict simply outturned the treaty architecture? I believe it's a very important question. And I think the question is for both speakers. So please, like however you would like to answer the questions in which order. Maybe let's start with Dr. Daza Vargas again.
Sure, I think it's a very difficult question, because the only way to understand the scope and the normative context of a provision is by testing it, and that is testing it in a dispute situation. So we have two different types of full protection and security clauses, right? We have full protection security clauses that only relate to discrimination. That is, if the host state pays to one of the foreign investors, they will have to extend this payment of compensation to many others. And then we have a more extended full protection and security clauses in which the state offers to pay for damages to everyone that has suffered that kind of damages. Now, the question is to what extent the state is going to do this in these war clauses. What kind of damages are there, by whom, for instance. We have tested some of this. Generally seizures of assets, damages, by the military, when they are carrying out operations, etc. Perhaps much less in the context of sanctions. Sanctions is starting to become a very important topic, and I think it's going to be the next topic of many PhD students. Is very important, but I think this is going to grow the knowledge on sanctions. I mean, we have been dealing with it for a very long time, but only now we are starting to see reactive actions of the countries that have been affected with sanctions against themselves. Weaponizing energy supply. Well, this is something that I perhaps have a little bit more experience in the context of water, in which in the case of the conflict in Palestine, water sources were affected and water was weaponized. Same in the case of Iran, there was an attack in a source of water, and this is not only this is much less an issue of protection of investors, but affects also the availability of the natural resource for operations. That aside of perhaps more important issues such as human right to water, accessibility, etc., right to health, and many others. So I will stop there and leave the floor for my co-speaker.
Yeah. Professor, do you want me to repeat the question, or would you like to?
No, it's okay. I will answer it directly, and my view would be that maybe conflicts have outrun the treaty architecture, and let's say if I take it from slightly the other side, I would say that for a decision maker, they will have to think how important is this relationship, how important is it in their supply chain, what's the reputational risk if they don't proceed, with that sort of business relationship. So I think, we are going to see the more claims or more disputes, but it's to me, it's going to come down to strategic choices rather than treaty architecture.
Thank you very much, Professor Heffron. Okay, Sophie, we have a couple of more questions on the Zoom link and also on the YouTube link. So I'll bundle the remaining questions to two for the time considerations. So the next question is from Anas Afifi. Regarding the risks related to foreign investments, how we can mitigate these risk factors, especially in relation to AI or advanced technologies? And from Emilia Onyema, for tribunals that will deal with disputes arising from the US-Iran conflict, how do you think that they will deal with the issue of foreseeability? So in essence, what is foreseeable? So the role of AI and the issue of foreseeability in determining the liability. So again, I want to give the floor to Dr. Daza Vargas and followed by Professor Heffron.
In terms of the risks, the mitigating the risk factors, especially, I really have no answer. I don't know. I agree that perhaps this is not about investment architecture. It's more about the expectations that the states create into different investments, the way they manage new technologies, the way they manage and put perhaps brakes into the fast advancement of AI. But I completely agree in this case that this has to be dealt with at the policy level first, in the domestic level. In terms of the US-Iran conflict, again, I have no definite answer. I mean, foreseeability is one of the elements in international law to in relation to causation and to the payment of compensation. So again, I mean, is a war foreseeable? Yes, to an extent, but there is also an obligation not to, by the United Nations Charter and all that, not to enter into war. So I'd say that I know, actually, I would not know what to say. You're right, but I have no idea how the tribunals in this case would decide. It's an interesting conflation of a tribunal there. You have an interesting group of people, so it would be nice to this is a new issue completely, at least for me. I wouldn't say that we could learn too much from the past anymore. I think the situation has changed, and I think that is something that arbitrators are starting to recognize. We cannot really look too much into the past and all disputes that originated the US-Iran claims tribunal. See, the situation is quite new. I am actually very interested in what tribunals might say.
Thank you, Dr. Daza Vargas. Professor Heffron, would you like to have your input?
So for the first one, I mean, I would echo Dr. Anna Maria's remarks that we're talking more about foreign investment, but if I'm thinking of AI and advanced technologies, I mean, they're meant to make our life easier. So I'm not sure that there should be so many risks attached to them when they should be making our lives easier. So I mean, if anything, they will assist in lowering some different risks and in different places, but obviously at very specific points in different sectors. For the next one, if is the US-Iran conflict the issue for foreseeability? Well, if I take the last question of Amelia, was the war foreseeable? I may change that question and go, is war foreseeable? And I would say yes. And I think that's comes into my point on resilience, and that you have to be operating with some plan to be a more resilient country, institution, company, etc. And if you can't show that, your claim should be impacted. I still think you would be, as it were, on the winning side, but I'm not sure how much you're going to get in terms of the dispute. But I think more and more we have to be able to say that a lot of things are becoming more foreseeable in this world, and you have to show that you've already taken a level of precaution in terms of your decision making. And to me, if you can evidence-base that decision making, will become very important. So I think it's a watch this space. This topic is going to grow and grow.
Thank you, Professor. So our next questions are from, and we have just a follow-up question from Mr. Enes Afifi about the role of like AI and advanced technologies, especially for the countries that already have issues with energy resources like electricity and data infrastructure, and how can we achieve fair trade in the world economy, especially for these like less developed countries, I believe, when it comes to data sovereignty, AI, and advanced technologies. And second question by Ismail Habib: how should investor-state arbitral tribunals reconcile the doctrine of military necessity under international humanitarian law with state obligations under international investment agreements when conflict-related measures adversely affect foreign-owned energy infrastructure? I believe, again, especially Dr. Daza Vargas touched upon this topic. So, like, if you'd like to elaborate on that, and if you want to give more input to the follow-up to the question by Mr. Afifi. So please, again, in the same order with Dr. Daza Vargas.
Thank you. So Ismail, question first. How should investor-state arbitration? Sorry, I'm really need to reconcile Dr. Afifi. Well, I think that was that's how I kind of started my speech by explaining what was the big concern back when we had to deal with the first armed conflict and investment protection disputes. And it was a question precisely under the draft articles on armed conflict and all that, what kind of agreements will still continue to be operating, and investment agreements and dispute settlement agreements were in that field. So that obligation of the state to protect foreign investment or foreign nationals, again, was still there. So rather than one or the other, or well, reconciliation is an intersection, and then we have to consider that in these intersections we need to find this balance. Now the balance is probably given, as I explained before, and in certain provisions of the agreements, and it's not only one of the provisions, but I think it's a combination of the provisions, because you can have a still situation of expropriation, you can still have situations of fair and equitable treatment, but particularly full protection. In terms of when conflict related to measures and adversely foreign energy infrastructure, I mean, in a situation of war, it's very difficult to determine what kind of assets are going to be affected. Sorry. So, sorry.
Dr. Daza Vargas.
Sorry, I 1 second. I have to get up 1 second. Sorry.
Okay. So, sorry. So, like, Professor Heffron, would you like to step in and give your input?
Yeah. So I think touching on the point that she was just finishing on, I mean, you know, foreign-owned energy infrastructure is always going to be at a, you know, it's always going to be in a risky situation. And I mean, that's why today we see a balance, you know, we see, let's say, a lot of state-owned energy infrastructure. And that's why I touched on during my talk that you have to be thinking about different strategies. And one strategy that some foreign-owned energy infrastructure companies might be thinking of, or those investors, would be of sharing ownership with a national company. So, and that, you know, helps mitigate the risk. And you can't always be 100% foreign owner of energy assets, perhaps in the modern world today. So, you know, it's about thinking a bit differently, because to me, the level of fragmentation is going up too high, where you know that there are risks involved.
Thank you, Professor. Dr. Daza Vargas, would you like to continue, or shall we pass to the last question?
With sincerest apologies, because I am working from home, and as you can see, I have a research assistant that barks. Well, no, I think I completely agree. I mean, with Rafael, because I think you have here the two levels of analysis of these issues, right? The level of the architecture of foreign investment that really has nothing to do with what Rafael is talking about. When we create policy, when we have strategies of mitigation, all those strategies need to be in place before states enter into these type of agreements, which obviously has not happened, and that's why we have a rebalance of investment obligations at so many different levels, right? We have UNCITRAL on the procedural issues. We had the OECD in connection to foreign investment and climate change, and also substantive issues in the track 1 and 2 that they have. We have UNCTAD. And this is because these domestic policies were never clear in place, or the situation that we are, transforming really fast, and having to tackle really big challenges on climate change, instability, political instability, geopolitical war, etc. So I don't think I have much more to say in terms of these energy infrastructures. Probably there are ways, but from the perspective of when the damage is already done, what investments agreement can do, there is, I think, you have assets that are treated, equally. It's just what is the damage to the host state in terms of the destruction of certain infrastructure, and how you are going to calculate potential compensation if a breach of the treaty is found.
Thank you, Dr. Daza Vargas. And our final question by Shimal Efsane from King's College London on YouTube. Anticipate a surge in international, I think the question, do you anticipate a surge in international arbitration cases as a direct result of the ongoing conflicts in the Middle East and Ukraine, given the severe distractions and the critical infrastructure during armed conflicts? How should investment tribunals balance a host state's reliance on essential security interests when seizing energy assets against the foreign investors' legitimate expectation and the broader global need to finance a just transition? So, like the intervention, the intertwined nature of the energy transition, the armed conflicts going on in the Middle East and in Ukraine, providing different challenges to the states to both like realize their energy transition and also to protect their national security in times of armed conflicts in the Middle East and Ukraine. So like, do you anticipate a surge in the investment arbitration or international arbitration cases? And like, how can we reconcile this if we can have a very like brief answers from the speakers on that? So Professor Heffron or Dr. Daza Vargas, who would like to take the floor on that? Very briefly. Yes, yeah.
I'll let my colleague go first.
Okay. Well, but maybe that's a good thing, because I think Rafael will have a final nice advice in terms of policy and national regulation. But I mean, at the moment, I think we are really going through the perfect storm, right? We are really dealing with climate change, and I think it cannot be deniable anymore, given these heat waves that we have witnessed, but not also like a very aggressive climate phenomena like rain or extreme drought, etc. I mean, this is something that we have to deal with and really become much more adaptable. When we talk about AI, I have to say that independently of how much the infrastructure will help and make our life easier, it's also going to require a huge amount of energy. And I think we don't consider as much that of how much and how these companies have to go to different countries and invest to try to find reliable sources of energy to maintain this, this infrastructure, to give the service that we need. Do we really need the service? To how much this can accelerate without being regulated before? So in terms of demand for energy and control of the demand of energy, I think this is, to me, one of the biggest questions. How much we really need this energy? How much can we actually start saving and start reducing our demand of, this culture of wanting things and needing things all the time? And this has nothing to do with investment or with energy. It's just something to do with us as humanity, and start really relenting our demands for goods.
Professor Heffron?
Yeah, and I'll be aware of the time and that everyone wants to finish maybe, but I'll just say very, very quickly, you mentioned the issue of new energy construction, etc. After a time of war, if I say that naturally after a time of war there will be significant new energy investment. Therefore, with more money being invested, there's naturally going to be more disputes. And when you add in issues of climate change, a move toward the energy transition, a move towards the just transition, I think that puts an emphasis on whether the right decisions get made in terms of building the right technologies. And if we don't see that happen, I think in 5 to 8 years we will see more disputes, because people will be able to say what is a good policy decision, or what is a good investment decision today or tomorrow. And I wonder, are some governments or some companies fully protecting themselves in terms of how they make decisions? And will investors in companies be able to bring about disputes over choices made in terms of strategic decision making by companies, as well as the general disputes? So for those people out there thinking about the next steps in their career, I think disputes are only going to go up in this area.
Okay, thank you, Professor Heffron. I thank for both speakers for their extremely valuable inputs and their remarks and their answers to the thought-provoking questions. And I thank everyone who tune in, who participate in this webinar. And I want to, before concluding, I want to give the floor to our Secretary General, Dr. Omar Husseini. Please.
Yeah, thank you very much, Dr. Omar. I don't know which of the Omars, whether it's me or you. You know, we have two Omars here today. Yeah, thank you very much for inviting the speakers and for moderating the session. And I would like to also thank Professor Hafran and Dr. Anna Maria, you know, for the excellent session. Really, I think personally, I learned a lot from the session. And, you know, regarding the energy transition part, I'm sure you're all aware that COP31 is coming up soon and it's going to happen here in Turkey, in Antalya. So you're all invited. And, you know, it's interesting to note that because, again, we've been listening to issues relating to energy transition, climate change. You know, the theme for this year, I think it's going to be around the, you know, implementation, basically. Yeah, we've been talking about AI, we talk about blockchain technology and all this, but the energy you need to run this, and this is what Dr. Anna was emphasizing on. I mean, it's huge, basically. I mean, this is something which, you know, we talk about clean energy, you know, talk about electric cars. Do you know what it takes to produce the battery itself? You know, so these are things we need to kind of consider. So I'm glad to see that, you know, this year's COP will be, you know, focusing on implementation. And they talked about the COP of the future and together for a cleaner future. I'm just reading the themes, you know, I got. So this is quite interesting. Last point. Yes, sir. I think Dr. Anna mentioned about the OIC treaty, and thank you, you know, but, you know, within the OIC, we consider it a dated kind of treaty now. Yeah, because again, there are some provisions that need to be updated. And yeah, there's an ongoing process to kind of modernize it. And we have a zero draft now. You know, member states are actually providing their opinions on every key provision, including the FETs, the MFN clause, and others. So hopefully we'll be able to conclude the process in the next few months or years. I don't know. I mean, you know how it takes, you know. But it's really interesting to know that you were involved in some of the Libyan cases. And yeah, you discussed earlier. Thank you for sharing that perspective. And of course, Professor Hafran, I like the dimension of looking at it from the policy perspective in terms of what we need to do going forward. And I think this dimension is really important in terms of energy security and the way forward, you know, ultimately. So again, I would like to thank you, the participants, for joining us today. Again, there's a monthly ritual for us at the OIC Arbitration Center. We hope to see you again next month. And thank you all, and enjoy the rest of your day. Take care. Bye-bye.